Welcome to the deep dive, where we get past the headlines and right into the essential facts.
Hello.
Today, we're tackling a debate that has, well, it's dominated British politics for years, hasn't it? The Human Rights Act, its cost, its status, and this perceived chaos surrounding it.
Absolutely. It's a constant feature of the news cycle.
It is. And if you listen to certain political speeches or just follow the news, you get this narrative that our courts are completely swamped.
The floodgate argument.
Exactly, the floodgate. That it's open, that judges are bogged down with frivolous claims, and that you've got people just shouting Article 8 to, undermine the rule of law. So our mission today is pretty straightforward. We are going to set aside all of that political rhetoric. We've got sources full of hard data, judicial reports, research papers, and we're going to use them to answer one question for you.
And that question is
the UK legal system facing a crippling human rights flood? Or is the reality, closer to a bit of an administrative trickle? We're trading loud opinion for quiet, verifiable data.
And that really has to begin with a bit of clarity, I think. Before we even get to the numbers, we have to be sure what we're actually talking about.
Okay.
Because the terms ECHR and HRA, they get used interchangeably all the time, and they really shouldn't be.
Right. So ECHR, that's the European Convention on Human Rights.
Yes. That's the international treaty set up after the Second World War. The UK was, central to drafting it. It just outlines the fundamental rights that signatory states agree to.
So that's the big international promise, the founding document. But a British citizen doesn't just take a case straight to an international court in Strasbourg based on that promise.
Exactly right. And that's the crucial bit. The Human Rights Act, the HRA, was passed in 1998. And that act is the mechanism that, it brings those international promises home.
It embeds them in UK law.
It does. It allows you to enforce those rights in a county court, a family court, or the High Court here in the UK, not just in Strasbourg.
So the HRA is sort of the local wiring, the domestic translation that lets people actually use these rights here.
That is a perfect analogy. So when we talk about the British system being flooded, we are specifically talking about the cases running through that local wiring, the HRA.
Within our own borders.
Within our own borders. Keep that local focus in mind because now we're going to introduce the first set of really big numbers.
Okay, let's do it. So if the courts are supposedly swamped, just how big is the pool they're swimming in? What's the total scale of the UK legal system?
Well, the scale it's immense. It's easy to lose sight of just how vast the machinery of justice is. The UK legal system handles roughly 4 million cases a year.
4 million. Let's just pause on that. So that's everything. Motoring offenses, small claims, huge corporate cases, criminal trials, family disputes, all of it.
All of it. That is the baseline. When you hear that the HRA is a system-wide blockage, you have to measure it against that total workload of 4 million cases.
Okay, so this is where the data really comes in. Out of that colossal number, that 4 million, what percentage of them are actually tied up in human rights law?
And this is where that political narrative just immediately collapses. The source material is very clear. Out of those 4 million cases a year, only about 1 to 2% even mention the Human Rights Act at all.
Hang on. 1 to 2%. Mention it. So for every 100 cases going through the courts, maybe 1 or 2 lawyers even bother to reference the HRA?
That's it.
Yeah.
We're not talking about successful claims here or even serious challenges. We're just talking about raising the point in passing.
Wow. Okay. Straight away, the idea that the courts are drowning in HRA claims, it just doesn't hold up to that basic number, does it?
It really doesn't. The sheer scale of the system, that 4 million cases, it completely contextualizes the volume. It's not a flood. It's a tiny, tiny tributary in a massive legal river.
It's an interesting thought, isn't it? The courts aren't small, and the case is huge. The courts are massive, and HRA usage is, extremely localized.
And that's the next key point. When the HRA is mentioned, the headlines always focus on those big controversial battles, don't they? Deportation, national security.
Yeah, the high-stakes stuff.
But if we look at that little 1 to 2% sliver of cases, the data tells a completely different story about what these claims are actually about.
Okay, so that initial figure is staggering. But let's dig into that sliver. Who is using the HRA and why? Where are these mentions actually popping up?
Well, the data shows that more than 80% of them are not challenges against central government policy at all.
80%. So they're not these grand ideological battles against Parliament.
No. Instead, they're being used in really routine, localized legal settings. Think about the family court, for instance.
Yeah.
Cases about child custody or adoption, or when a local authority has to intervene. They are constantly referencing the right to family life. That's Article 8 of the ECHR, brought into UK law by the HRA.
Right. And Article 8 is the one that always gets the sensational coverage about immigration. But what you're saying is its main day-to-day job is making sure local councils respect family structures when they make decisions about kids.
Absolutely.
Yeah.
And beyond the family court, they pop up in mental health tribunals, to ensure the rights of people detained are protected. They appear in homelessness decisions, prisoner welfare cases, domestic violence protection orders.
So for the vast majority of its use, the HRA is acting like a layer of guaranteed fairness for pretty normal people.
That's a great way to put it. It's not some weapon against the state. It's more like an instruction manual for local administrative justice.
It lets a lawyer say, hang on, before you evict this family, you have to show that you've properly considered their fundamental rights.
Precisely. It supports the fair delivery of justice. It doesn't obstruct it. The narrative we hear, that it's mainly for foreign criminals fighting deportation, is statistically just inverted. Its main job is ensuring due process for vulnerable citizens.
Okay, let's pivot then. Let's look at that small slice that does grab the headlines. The direct challenges to central government policy. The cases brought through judicial review.
And we should probably just clarify what judicial review is quickly. When we talk about JR, the court isn't rerunning the politics of a government decision. It's not about whether a policy is good or bad.
Right, it's about the legality.
It's about the legality. Was the process fair? Did the department act outside the law? Did they consider the right factors? The court is just asking, in making this policy, did you legally meet your human rights obligations?
So it's like checking the homework, not rewriting the curriculum.
That's a good way of thinking about it.
So if we narrow our focus just to those high-profile judicial reviews, what do the numbers look like there?
We are talking about a tiny fraction of that initial 4 million. The number of actual judicial reviews that even mention the HRA is somewhere between 350 and 600 per year.
Less than 600 attempts in a country of 67 million people to challenge the central government on rights grounds. Okay? But attempting isn't succeeding. What's the success rate?
And that shrinks dramatically. Most of these cases settle, or they're ruled inadmissible. The number of actual successful challenges, the ones that force the government to overturn or rethink a decision across all departments, is only about 35 to 120 per year.
I just want to pause on that. A maximum of 120 successful challenges against the central state in an entire year. That works out to, what, one successful challenge every 3 days for the whole of government?
Roughly, yes.
That is not a legal apocalypse. That sounds more like very high administrative efficiency, or at least a system that's very resilient to legal challenge.
It absolutely suggests the legal system is a minimal check, not a constant roadblock. But what's even more telling is why those few challenges succeed. It's rarely a judge inventing some new moral law.
So what are the common causes for a successful challenge then?
The sources are incredibly consistent on this. The cases that succeed are usually overturning decisions because of things like unlawful detention, poor reasoning, procedural mistakes, an agency overreaching its legal authority, or, and this is a common one, failing to properly consider the impact on children.
So when the government loses, it's not an ideological defeat. It's an administrative failure. They're being told you didn't do your due diligence, not you can't have this policy.
That is the most important insight from this data, I think. The HRA, in this context, is primarily a tool for good governance. The courts are holding agencies accountable to their own rules. They're correcting avoidable mistakes.
It really does reframe it, doesn't it? It's less a source of instability and more a crucial quality control mechanism for this vast administrative state.
That's right.
Okay, let's address the final area where the rhetoric is often loudest. The cost. Even if the challenges are rare, the argument goes, they are so expensive that they're bleeding the public purse dry.
This brings us to the financial data. And yes, litigation is expensive. For the government, a straightforward judicial review might cost them between, say, £15,000 and £40,000 to defend.
Win or lose?
Win or lose. More complex cases can run higher, maybe £70,000 to £120,000. But when you add it all up, the total annual cost across the entire central government for these rights-related challenges comes to maybe 20 to 30 million pounds.
Now, 30 million pounds is a huge amount of money in absolute terms, but you have to put it in context.
You have to. And you have to set that figure against the spending power of the government. Let's just take the Home Office, which is often the department most involved. The Home Office budget alone is well over £20 billion.
So, if the total annual cost for the entire government is $30 million against a £20 billion budget for just one department, we're talking about a fraction of a percent.
Numerically, it's a rounding error in terms of national finance. It is minimal. And what's more, the sources raise an even more crucial point that completely undercuts the cost argument.
Which is?
These litigation costs would largely still exist even if the Human Rights Act vanished tomorrow.
Explain that. Why wouldn't the costs just disappear if the HRA did?
Because the underlying reason for the challenge, the unlawful detention, the poor reasoning, the overreach of power, that would still exist. And people subject to those things still have rights under common law, under administrative law.
They'd just sue under a different name.
Exactly. The litigation wouldn't disappear. It would just be brought under different legal labels. Judges would still have to intervene to make sure the state acted lawfully. Removing the HRA just removes the most direct and efficient tool for doing that. You might even increase the cost by forcing cases down more complex legal routes.
So what does this all mean then as we wrap this up? Let's bring all the numbers back together.
Okay, we started with 4 million total cases a year in the UK system. That massive number funnels down to only about 10,000 cases that even mention the Human Rights Act.
And of those, only 350 to 600 try to challenge central government.
Which then drops to a maximum of about 120 successful challenges a year, usually correcting procedural mistakes.
At a financial cost that is, in the grand scheme of things, negligible.
The data paints a really clear picture. The courts are not bursting at the seams. The HRA functions as a small but critical safety valve that occasionally says, Nate, that decision needs a rethink.
It's the judicial equivalent of holding a huge bureaucracy accountable to its own operating manual. It's not political gridlock, it's systemic quality control.
And that leads us to a final provocative thought for you to consider. If these successful challenges nearly always point to poor reasoning or avoidable administrative error, how much public cost, both that $30 million in legal fees and the cost in lost public confidence and time, could be saved if government agencies simply prioritized robust procedure and good reasoning in the first place?
It flips the script entirely, doesn't it? It shifts the focus from an ideological battle over the law itself to a much more practical concern about basic administrative competence. Something for you to mull over. Thank you for diving deep with us into the facts.